Hello, this is Nicholas Traylor, Executive Director of the Richmond Rent Program. Today's presentation is on how to assert your rights as a tenant in Richmond. Topics covered today include what is the rent ordinance and what rights does it afford to tenants, how the Fair Rent Just Cause for Eviction and Homeowner Protection Ordinance, we'll call it the rent ordinance hereafter, really levels the playing field for tenants in Richmond. We're going to talk about how to assert your rights to lawful rent, how to assert your rights to habitable housing and stable housing services, and how to assert your just cause for eviction rights. But let's start with the purpose of the rent ordinance. The purpose of the rent ordinance is to promote neighborhood and community stability, healthy housing, and affordability for renters in the city of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while ensuring landlords a fair return. As I mentioned, the rent ordinance levels the playing field for tenants in Richmond. And to illustrate that, I'm going to talk a little bit about what it was like for tenants prior to the rent ordinance and after the rent ordinance's passage. So before the rent ordinance became law, tenants could be evicted for any or no reason. Although there are federal laws that prohibit discriminatory evictions, in reality in Richmond, a tenant could be evicted for no fault of their own and also receive no relocation assistance. Rents could also be raised without limit. So prior to the rent ordinance becoming law, tenants in Richmond were experiencing rent increases up to 30%. And tenants in Richmond had limited recourse to compel landlords to provide habitable living conditions or address a reduction in housing services. At the time, tenants' only recourse was to sue in small claims court or superior court. Now, after the rent ordinance became law, tenants could only be evicted if the landlord had at least one of the 8 just causes required to evict. And tenants have a right to relocation assistance if they are evicted for no fault of their own, such as an owner move-in eviction, or when the landlord wants to go out of the rental business through the Ellis Act. And rents for controlled rental units could only be raised annually, or can only be raised annually by inflation based on the consumer price index for the Bay Area, or if the landlord petitions to receive a fair return rent increase through the rent adjustment petition process. Now, tenants also have recourse to deal with rent overcharges or reduction in services, or to deal with habitability issues. They have recourse through the rent adjustment petition process. Now, the rent adjustment petition process is a tool that tenants can use to compel landlords to provide habitable living conditions and maintain housing services that have been included in the rent. Before we get into discussing how to assert your rights, I think it's important to just get a general overview of the Richmond Rent Ordinance. So some of this might seem duplicative in terms of the information, but I think hearing it more than once is always a good thing. So first, under the rent ordinance, rents are stabilized. You have stabilized rents, and they're stabilized through these limited annual general adjustment rent increases, which in Richmond are based on 100% of the consumer price index. Now, those rent increases that have taken place since the inception of the rent ordinance have been on average around 3%, 3 to 4%. Just recently, because of increases, significant increases in inflation, this year's increase is 5.2%. Now, in Richmond, tenants who have lived in their unit since before July of 2015, and tenants who started their tenancy after that date had a right to have their rent rolled back to the rent that they were paying on July 21st of 2015, or the first date of a newer tenancy prior to January 1st of 2017. Additionally, tenants in Richmond have eviction protections. So as I mentioned before, landlords must have at least one of the 8 just causes to terminate a tenancy or evict, and must pay relocation assistance for no-fault evictions, such as owner move-ins. And under the Richmond Rent Ordinance, rents are adjustable, which means that a tenant can petition the rent board to reduce their rent due to a reduction in habitability, a reduction in housing services, or the number of roommates allowed. So if the landlord reduces the number of roommates that are allowed, the tenant can actually get a rent reduction for that. And landlords also have a right to file a petition, and they can increase their rent above the maximum allowable rent by filing a fair return petition. So in order to understand your rights, you need to know how the rent ordinance applies to your particular housing situation. And the rent ordinance can apply differently depending on what type of property you live in. So let's talk about fully controlled or fully covered rental units. And those are rental units that have both rent control or rent stabilization and just cause for eviction protections. So if you live in a multi-unit property that was built on or before February 1st of 1995, you live in a rent controlled unit, and you have rent stabilization or rent control and just cause eviction protections, meaning the landlord has to have one of the 8 just causes to terminate your tenancy. And then there are properties that are partially covered by the rent ordinance. And these types of properties do not have any rent control. The rents are not controlled. However, just cause eviction protections still apply. These types of properties include subsidized units, including Section 8 tenancies, as well as affordable units, properties with one dwelling unit on a parcel, also known as single-family dwellings, condominiums, and properties that were constructed after February 1st of 1995 with permits. So those are partially covered rental units. So if you live in a condominium or single-family home, or you're a Section 8 tenant, we don't control your rent. However, we do control evictions, which means that the rent ordinance requires that the landlord have just cause in order to terminate a tenancy for a tenant who lives in a partially covered rental unit. And there are units that are fully exempt from all provisions of the rent ordinance, where there's no rent control and no just cause eviction protections. And these types of properties include rentals where the tenant shares a kitchen and or bath with the landlord, or if the tenant lives in a unit where that was added to a single family dwelling with permits, and the main house is owner occupied. And then retirement homes are also fully exempt from all provisions of the rent ordinance. So let's examine eviction protections a bit more. So in Richmond, as I mentioned before, in order to terminate a tenancy for the vast majority of tenants, a landlord must have one of the 8 just causes that are enumerated in the rent ordinance. Those just causes include failure to pay rent, but that's only after the tenant was served a 3-day notice to pay rent or quit and did not pay. Breach of lease is another just cause, and that's if that occurs if a tenant continues to violate the lease after being warned in writing to cease the violation or violations. Nuisance is also a just cause, and just like with breach of lease, the tenant has to continue to cause a nuisance after being warned in writing to cease causing the nuisance. Another just cause is failure to give access, and that's when a tenant continues to deny a landlord lawful entry under Civil Code 1954 after receiving a written warning notice to cease denying lawful entry. And just for those who are not aware of Civil Code 1954, this is the state law that allows landlords to enter to make necessary or agreed upon repairs or to show the unit, but it requires the landlord give at least a 24-hour written notice prior to entry, and it can only be during normal business hours. There's more to that law, and if you have any questions about that law, of course, you should contact the rent program. So failure to give access is a just cause. Another just cause is if the landlord has to temporarily terminate the tenancy in order for the landlord to make substantial repairs. In this type of temporary eviction, a landlord is required to pay relocation payments. And in most cases, it would be a temporary relocation payment that is a daily per diem amount that must be paid to the tenant in those circumstances. Another very significant just cause is owner move-in eviction. And that includes owner relative eviction. And owner move-ins require at least a 60-day notice in most cases, and require the landlord to pay permanent relocation assistance to the household as part of the process of terminating the tenancy. Another just cause is withdrawal from the rental market. This is also known as an Ellis Act eviction, and this is a state law eviction that allows the landlord to go out of the rental business, but it prohibits the landlord from renting the unit for a certain number of years, and the eviction is recorded on the deed of the property, meaning that even if the property is sold, a new owner would be faced with the same restrictions that the withdrawal placed on the property. And this type of eviction also requires permanent relocation monies to be paid to the tenant by the landlord. There's a complicated law with different noticing requirements. And if you have any questions about withdrawal from the rental market, again, contact the rent program. And then finally, there is a just cause for eviction known as a temporary tenancy. And a temporary tenancy can only occur if the property is a single family home or condominium, and the property is the landlord's primary residence, and the landlord and the tenant agree in the terms of a lease agreement that the landlord will return to the unit within a 12-month period upon which the tenant must vacate. So for example, if the landlord wants to take a job in another country for 10 months and wants to rent out their condominium or their house, well, they can do that and put it in the lease that the tenant must vacate when they return within that 10-month period, and the tenant does not have a right to relocation assistance in that situation. There are some pretty important written warning notice requirements under the rent ordinance. And what that means is that prior to the landlord serving a notice of termination of tenancy or eviction notice on the tenant for breach of lease, nuisance, or failure to give access, the landlord must issue a written warning notice to the tenant to correct the breach of lease, to correct the nuisance, cure the nuisance, or to cease denying the landlord the right to lawful entry. When giving this written warning notice, the landlord must provide the tenant with a reasonable period of no less than 5 days to correct the violation prior to serving a notice of termination of tenancy. The landlord must also state that failure to cure the violation or violations may result in eviction, and must inform the tenant of their right to request a reasonable accommodation, perhaps so that the tenant maybe the tenant has a disability and requires extra time in order to cure the violation or nuisance, or to allow the landlord lawful entry. And the written warning notice must include the contact number for the Richmond Rent Program and instructions for how the tenant can cure the violations or come into compliance. And it must also include information necessary to determine the date, time, place, witnesses present, and other circumstances around the lease violation or nuisance or failure to give access incident. And we do have a written warning notice template that's available on our website. But just remember, as a tenant, if you receive a breach of lease, nuisance, or failure to give access notice, the landlord must have given you a written warning notice first. It's also important to bear in mind that at the time of this presentation, the City of Richmond still has an urgency ordinance that is in place. This urgency ordinance is also known as the Richmond Eviction Moratorium. And under the Richmond Eviction Moratorium, breach of lease, nuisance, and failure to give access are currently prohibited. Those types of evictions are prohibited under that eviction moratorium. Nuisance can be allowed if it's a threat to the health and safety of occupants or the landlord, but currently landlords are not able to perform breach of lease, non health and safety related nuisance situations, and failure to give access. There are also important noticing rules under the rent ordinance and under rent board regulation 1001. So under 1001, if a landlord issues a notice of termination of tenancy on a tenant or serves a notice of termination of tenancy on a tenant, the landlord must provide the rent program with a copy of that notice within 2 business days of having served the tenant. And they must include a proof of service to the rent program that demonstrates that and declares that they have served the tenant this notice. Now, the notice of termination of tenancy can be submitted by landlords online. We have a portal for that. And for larger properties, landlords can submit the notice by mail. But in any case, it's important to know that perhaps the most important thing to know with regard to this, the noticing rule, is that if a landlord fails to provide the rent program with a copy of the notice of termination of tenancy within the 2 business day deadline, the tenant may be able to use that as a defense, an affirmative defense to an unlawful detainer or eviction lawsuit or proceeding. I want to talk a little bit more about how rents are stabilized in Richmond. So let's start with the creation of the base rent and the rent rollback. So under the rent ordinance, rents are required to be rolled back to the rent that was in effect on July 21st of 2015, or the rent in effect on the first date that rent was charged after July 21st of 2015. For example, let's say there was a tenancy that started September of 2014, and the tenancy begins with rent at $1,000. And in December of 2015, the rent was raised by $100 to $1,100. Now, on December 30th of 2016, the rent ordinance went into effect. And I want to just go back a little bit further. You'll notice that in July of 2015, the tenant was paying $1,000. That amount paid on that date is the base rent upon which the tenant's rent controlled rent is calculated. Now, if December 30th, 2016, the rent is rolled back to $1,000. In other words, the landlord who raised the rent in December of 2015 by $100 is not allowed to keep that $100 rent increase. They had to roll the rent back to $1,000. And then in January of 2015, or February of 2015, after the landlord gave proper notice that the rent could be increased by the 2016 annual general adjustment, which is the allowable inflationary rent increase. They were allowed to increase it by 3%, and the rent could be raised to $1,030. And then each year after that, the same applies. The $1,030 is then multiplied by the next year's percentage increase that is allowed. But it's important to note that there have been tenants whose rents were never rolled back. And so after January 1st of 2015, the landlord was continuing to pay that, in this particular circumstance, that extra $100. And all that $100 rent increase, if not rolled back and if not removed, and the tenant refunded it, or any rent overcharges, can accumulate to a very large amount of money. So it's important to know, did you have your rent rolled back? If you didn't, you should contact the rent program so we can assist you with getting that situation addressed. And again, I just want to show everybody, this is a brief example of how rents are raised in Richmond. We'll talk a little bit about the maximum allowable rent and what that is. So basically what you have in Richmond is you have the base rent, and that's the rent you paid when you first moved in. And if you moved in on or before July 21 of 2015 is the rent that you paid on that date. And then each year, the rent can be increased by inflation, by the annual general adjustment, which is the cost of living or inflationary rent increase that is allowed. As you can see, it's applied to each, to the previous year's maximum allowable rent and compounded like that every year. And of course, the landlord must give a 30-day written notice of rent increase in order for the rent increase to be valid. And they must give provide a copy to the rent program within 10 business days of having served the tenant the rent increase notice for the notice to be valid. So let's talk a little bit about the annual general adjustment, the yearly increase, the annual increase that is allowed in Richmond. So what is the AGA and how is it calculated? Well, the AGA is the annual allowable cost of living increase, as I mentioned before, and it is based on 100% of the consumer price index or inflationary rate for the Bay Area. When can the first annual general adjustment or AGA be taken after a new tenancy starts? In order for a landlord to take the annual general adjustment after a tenancy starts, one full calendar year must expire after September 1st of each year. Another way of putting that is the tenancy had to start prior to September 1st of the previous year in order for the landlord to take the September 1st rent increase each year. And that's the next question is, when during the year can the AGA be taken? The AGA can be taken on September 1st of each year after proper legal notice. And of course, it could be taken on or after that date each year. Additionally, landlords who haven't taken increases each year are allowed to bank those increases. So put them in a metaphorical bank, so to say. What that means is, let's say 3 years of increases have occurred, and each year the increase was around 3%. Well, the landlord can't take a 9% rent increase all at once because they didn't take 3 years of rent increases. They actually can only take the current year's increase plus 5% of the previously deferred increases. So for example, in 2021, the allowable rent increase was 1.6%. And let's say the landlord hadn't raised the rents for 3 or 4 years and had more than 5% in deferred increases. Well, they can take 1.6% plus 5, or about 6.6%. Now, landlords are allowed to take this annual general adjustment rent increase annually, but there are requirements for them to be able to take it. So those requirements include that the landlord must be in compliance with all aspects of the Richmond Rent Ordinance, including they have to enroll the property with the rent program, they have to pay the rental housing fee, which funds the rent program, and they have to make sure that they properly roll the rents back, and any rent overcharges were refunded to the tenant. The landlord must also provide the rent program with a copy of the rent increase notice, along with a proof of service within 10 business days of having served the tenant. Failure to do so could render the notice of rent increase, the annual general adjustment rent increase notice, as invalid. And the landlord might actually have to refund those increases to the tenant if the rent program was not notified within that 10 business day deadline. And it's important thing to remember that only properties that are subject to the rent control provisions of the rent ordinance must follow the rent increase noticing requirement. So in other words, units that are partially covered, so single family homes and condominiums, for example, or subsidized units, the landlord is not required to provide a copy of the notice of rent increase to the rent program because those rental units are not rent controlled. So another major aspect of the rent ordinance is that rents are adjustable, and rents are adjustable through the rent adjustment petition process. And for tenants, the rent adjustment petition process includes a petition for excessive rent due to failure on behalf of the landlord to roll the rent back or for charging rent above the maximum allowable rent. And that's another way of saying the tenant can petition for a rent reduction if the landlord is overcharging the tenant or never rolled the rent back. Tenants can also petition to reduce the rent due to a decrease in space, services, and or habitability. So if the unit is deteriorating, or there's code violations, or the space, the rentable space, usable space has been reduced, or housing services have been taken away, such as maybe the unit had a dishwasher and the dishwasher broke and the landlord never replaced it. That is a housing service that was reduced, and the tenant can petition to reduce their rent with the rent program. Tenants can also petition to reduce the rent due to a reduction in the number of tenants allowed. So if you moved in with 3 people in a rental unit, and after a certain number of years, let's say one of the tenant moves out, and the landlord says to the remaining tenants, tells the remaining tenants that they know the owner no longer wants there to be 3 people living in that rental unit, and now only 2 people can live there. And in that case, a tenant can petition to reduce their rent by the percentage number of occupants that are disallowed. So, for example, if 3 people moved in originally, and 1 tenant moves and the landlord doesn't allow for replacement of that roommate, the rent could be reduced by 33%. Now, there's some important petition facts. So first of all, when a tenant files a petition, a landlord has a right to object to the petition in writing. And most petitions, and almost all habitability petitions, result in a hearing conducted by a rent program hearing examiner. And some petitions that are filed may not actually lead to a hearing and may be decided administratively by the hearing examiner if no objection is filed by the other party and the facts of the case are straightforward and not disputed. It's also important to note that either party can appeal a hearing examiner's decision. Now let's get into the juicy part and talk about how to assert your rights as a tenant. And I like to start off with a question. So I wrote, Dear Rent Program questions. So the first question is, and then we're not going to answer this question directly, but it will give you an idea of how to deal with a situation like this. If you had a question about possibly being overcharged. So this question is, how do I know if the rent amount I am paying is lawful? My rent was just raised by over $100. The landlord claims that they hadn't raised my rent in years and that they are catching up. Please advise. So if you are a tenant and you receive a rent increase notice or have received rent increase notices that you are unsure are lawful, the first step is to find out if you are paying your lawful rent. And you do that by contacting the rent program to speak with a rent program services analyst or one of our housing counselors. And of course, you can reach us at 234-RENT or rent@ci.richmond.ca.us. And you can ask your question via email or by phone. And prior to actually speaking with the housing counselor, you're going to want to prepare some important information for the housing counselor. The first bit of information the counselor is going to need is what's the type of property that you live in and the address. We're going to need that information to determine whether or not you have a right to file a petition in the first place, and also whether or not the property is in our system and enrolled with the rent program. We're going to need the move-in date and the rent amount paid when you moved in. Now, if you moved in prior to July of 2015, July 21st of 2015, you need to provide the amount you paid in rent in July of 2015. You will also want to have prepared, if possible, a list of the rent increases that you have seen or received since you moved in. That's step 2, preparing key information for the housing counselor. Now, step 3 occurs if it appears that you've been overcharged. And that if you have been overcharged, you have several options for resolving the issue, which include start writing a letter or email to the landlord that outlines the issue and how you were overcharged. It also includes informing the landlord that you will file a petition or may file a petition to reduce your rent and seek a rent refund for overcharges if appropriate action is not taken by the landlord, which would include reducing the rent to the appropriate amount, the maximum allowable rent, and refunding any rent overcharges. And generally, you want to give the landlord at least 10 business days or 2 weeks to for the landlord to respond regarding your request to reduce the rent and refund overcharges prior to filing the petition. Now, in some cases, the communication between the landlord and the tenant has broken down. And in that case, if you don't want to deal with trying to convince the landlord, write the landlord a letter explaining how you've been overcharged, you can always skip that step and go straight to filing a rent reduction petition. Another option that you do have prior to filing the petition is to request rent program mediation, to utilize one of our rent program mediators to reach out to the landlord regarding the rent overcharges and the claims that the tenant has, to see if the landlord would be willing to reach an agreement with the tenant to reduce the rent to the appropriate amount and to refund any rent overcharges. Now, this next one has to do with habitability issues. And so let's read this make-believe email. My name is Nikki, and I live in an older apartment complex in Richmond. My apartment has lots of issues, and the landlord takes months to fix anything, often doing the work for himself and making shoddy In fact, when my water heater went out, it took 3 months to repair it. My family had to take cold showers or boil water to take a warm bath. Other issues include persistent mold, especially in the winter, a toilet that backs up regularly, and electrical outlets that short out easily. In fact, one time the outlet sparked and could have caused a fire. How do I get my landlord to fix things and provide me with a rental unit that is more habitable? So, to assert your right to habitable housing and to assert your right to stable housing services, you're going to need to take some steps. And there are 4 steps in this process. The first is to document. So a tenant cannot receive a rent reduction or rent refund due to the reduction in habitability or housing services unless it is documented that the landlord knew about the problem and didn't respond in a timely manner. Therefore, you want to document the problem or problems as much as you can. Send complaints via letter, email, text, and take photos and or videos of the problem. An effective complaint letter is one that memorializes the issues chronologically and how the issue was handled by the landlord. Now, step number 2 is to contact the rent program. And when you contact the rent program, you're going to learn about your right to file a petition. You're going to learn about the option to resolve the dispute through mediation or to use what are known as self-help options. I'll talk a little bit more about the self-help option later in this presentation. You'll also learn about your rights and whether or not you have a claim for rent overcharges. You'll also learn about the state law known as California Civil Code 1941.1 that requires a landlord to provide a habitable unit. And so you're going to learn a lot just generally about your rights. And so step 2 is a very important part of the process. Now, step 3 is optional, but it is highly recommended that a tenant who is dealing with habitability issues or has had housing services that have been reduced may want to consider requesting a housing inspection from the city of Richmond. So you can contact a city housing inspector and the inspector will come to your unit and cite the landlord for any code violations that exist. The landlord would be given a deadline by the city to correct the issues and may potentially face fines if the code violations or habitability issues are not corrected within that deadline that's given. And a report from the inspector can be used as evidence in a rent adjustment petition as well. So getting a housing inspection is a very effective way of compelling a landlord to make repairs. And it should be noted that it's a retaliatory action and it's against the law to retaliate against a tenant who has requested a housing inspection. Now, step 4 would be filing a rent reduction petition or requesting mediation. Those are the 2 main ones. There's actually one more, and that's the self-help method, but I'll get into that later on, as I mentioned. So step 4 would be filing the rent adjustment petition to reduce your rent, which could include a rent refund for past issues that were not dealt with. You can also request mediation as an alternative to filing a petition. Mediation, I think, is a good way to resolve issues prior to taking a more legalistic approach, which filing a petition would fall in that category. And it also allows both parties to negotiate a resolution without going through the formal rent adjustment petition process. And also it allows them to kind of set the terms of their agreement that are more customized to their situation. So this hypothetical email points us to the issue of how to assert your rights around your eviction protections. So in this one, the tenant writes, I received an eviction notice yesterday. The landlord claims that I am causing a nuisance and violating my lease agreement. I'm concerned because I think the landlord wants me out because I pay low rent, and we've had several disputes in the past. What are my rights in this situation? I don't want to get evicted. So to assert your just cause for eviction rights, there are additional steps as well. The first step is if you receive an eviction notice, you want to contact the rent program as soon as possible. First of all, to make sure that the reason for the termination of tenancy is allowed under the rent ordinance. For example, many tenants receive notices that are not lawful, such as a notice that says the tenant must vacate due to the sale of the property, or because the property has foreclosed, or because the lease has expired. And those are not just causes for eviction in Richmond. The rent program will also check to see if the landlord is in compliance with the rent ordinance and with the eviction noticing requirement. And that's because failure to follow the eviction noticing requirement and failure to be in compliance with the rent ordinance can be used as a defense to an eviction lawsuit. Now, step two, I want to talk about if you specifically receive a 3-day notice to pay rent or quit. First thing is that you may be eligible to receive rent assistance. And the rent program can connect you to an agency that provides emergency rent assistance. The rent program also contracts with legal aid service providers, including the Eviction Defense Center and Bay Area Legal Aid. And we may refer you to the Eviction Defense Center or Bay Area Legal Aid for legal assistance or representation. Now, the next step occurs is if you receive a breach of lease, a nuisance, or failure to give access notice. Now, if you receive this type of notice, you want to make sure that the landlord has first followed the written warning notice requirement, which provides the tenant an opportunity to correct the lease violations. And also in these types of evictions, it's very likely that we may refer you to the Eviction Defense Center or Bay Area Legal Aid to seek legal assistance to defend against the eviction attempt. Now, if you receive an owner move-in or a withdrawal from the rental market notice or a notice to vacate due to a government order, again, you should contact the Richmond Rent Program to inquire about any protections that you may have. And there are protections against owner move-ins if the tenant has lived in the property for 5 years or more and is disabled, 62 years old or over, or terminally ill. And there are also currently, there is a current local moratorium on owner move-in evictions. So you may have protections that you want to find out about, and you will find out about that easily by contacting the rent program. You also want to make sure that you know about your right to receive relocation assistance for these types of evictions, as the landlord is required to pay permanent relocation monies to a tenant household if they are evicted for owner move-in, withdrawal from the rental market, or if the tenant must vacate due to a government order to vacate, such as a red tag. And again, I mentioned you may have additional protections and rights with these types of evictions. Some of those rights may include the right to first right of refusal to re-rent if the unit is ever re-rented in the future. And if it's a rent-controlled unit, not only the right to move back in, but the right to move back in at your old rent, the rent that you were paying when you were evicted, plus any intervening cost of living increases or AGA increases. I want to talk a little bit about self-help. I mentioned self-help in previous slides, and one of the important roles that the rent program plays is educating the community, educating tenants on how to assert their rights, what their rights are. And the self-help method is a method that essentially means you're acting as your own advocate. In other words, it means trying to work things out with the landlord, quote unquote, on your own, without the direct involvement of the rent program, attorneys, or community advocates. Now, I put in quotes on your own because you're really never on your own. You can, of course, and you should contact the rent program to find out what your rights are and use that information to arm your self-help efforts. So the self-help method really requires on doing your research. And that means looking online on our website and other sources regarding your rights as a tenant. Now, once you're armed with information about your rights, the next step is to contact the landlord in writing to inform her about your complaint or the issues and your rights under the law related to that issue. Now, you're going to write an email or letter that memorializes the issues at hand and then ties those issues to your rights under the appropriate law. So for example, if the landlord is entering your unit without giving you proper notice, and it's a violation of California Civil Code 1954, you would memorialize the incidents that occurred where the landlord entered illegally, and then remind the landlord of their obligations under state law to give proper written notice prior to entry and explain, what type of entry the law allows and the parameters around that entry. Now, I do think that while you're writing your letter, it's always a good idea to contact one of our analysts to get a good summary or outline of your rights prior to writing that letter. And of course, keep a signed copy of everything that you send to the landlord. I want to talk a little bit more also about rent program mediation. So tenants in Richmond can request mediation and to resolve disputes with their landlord. And mediation takes two forms here at the rent program. The first is informal mediation. With informal mediation, you can request it via email, and after you've requested mediation, you'll speak to one of our housing counselors to learn more about your rights, and usually the counselor that you will speak to will be the mediator that will reach out to the landlord. When the mediator reaches out to the landlord, they're going to, of course, listen to the landlord's story and see where they're coming from. And after hearing both sides, the mediator will perform what's known as shuttle diplomacy, where each side is contacted separately, one after the other, until a resolution is reached. Now, formal mediation also requires requesting mediation in writing to the rent program. And after requesting mediation, rent program staff may decide that your situation requires formal mediation. During a formal mediation, both parties participate together, either in person, which occurred pre-pandemic, or via Zoom or a telephone conference. And the mediator may break up the parties to have separate discussions during the mediation, but ultimately the parties are able to express their concerns with the other party present, and with a mediator helping facilitate the dialogue. And after a formal mediation, a formal mediation agreement may be put together by rent program staff. And finally, I'd like to talk a little bit more about the rent adjustment petition process. I did talk about it, in some of the previous slides, but I want to, I'm leaving this for last because it is the recourse, the recourse available to tenants through the rent program to correct rent overcharges, to deal with habitability issues, and so on and so forth. So the rent adjustment petition process allows a tenant, as I mentioned before, to petition to reduce their rent or refund rent overcharges due to a reduction in habitability, space, housing services, or the number of roommates allowed. And the process works as follows. The tenant would first contact the rent program, speak to a rent program analyst, one of our housing counselors, to discuss their options and whether there are grounds for filing a petition. And the tenant may work with the housing counselor to help understand and actually complete the petition. The next step would be filing the petition. Here, the tenant would be filing several petition forms and attaching evidence or documentation to support their claims for a rent reduction. And upon submitting the petition to the rent program, the tenant must serve a copy of the whole petition packet, including all of the documentation, along with the proof of service to the landlord. And that's because this process is somewhat similar to the process in court, in that each side has due process, the right to object to whatever the claims are, and to submit their own evidence to counter whatever claims have been made. And towards that end, if a tenant files a petition to reduce the rent, the landlord has a right to object in writing within 20 days from when the petition is processed and the objection notice is sent. A little bit more about the petition process. Once the objection period is over, a hearing is scheduled. And when you have a hearing, you have a combined settlement conference scheduled right before the hearing, and that gives the parties an opportunity to reach a settlement and not go through the whole hearing. If a settlement is not reached, then the rent board hearing examiner will hear the case, listen to both sides, take evidence, and then after the hearing, usually within some weeks, the hearing examiner sends all parties his decision. Now, as I mentioned before, the hearing is similar to, but it's actually more informal to what actually happens in small claims court. Now, the decision of the hearing examiner may be appealed by either party within 35 days from the date of the decision. And if the decision is appealed, then a final hearing will be scheduled and would be adjudicated by the 5-member Richmond Rent Board. And that concludes the presentation. I thank you for listening, and I encourage you to contact the Richmond Rent Program, speak with one of our housing counselors to learn more about your rights, to see whether or not it makes sense for you to approach your issues through the self-help method, through mediation, or through the rent adjustment petition process. Again, you can reach us at 510-234-RENT or email us at rent@ci.richmond.ca.us. And this presentation is available and will be available on our workshop page at www.richmondrent.org/workshops. And with that, we are done with the presentation. Thank you very much. I hope all of you stay safe and healthy. Thank you.